Hello and welcome to our session on estate planning top tips. I'm John Grundy. I'm a partner in our private client team here at Mills and Reeve, and I'm joined today by three members of the private client team: Adam Williams, Jacob Cork and Stephen Atkinson. So the idea today is that we're going to provide a few ideas, a few tips across a number of different areas. So we're going to begin with Jacob, and Jacob's going to talk about will structuring. In particular, he's going to focus on will structuring for business owners and landowners who own assets qualifying for relief from tax. He's also going to touch on how one may deal with foreign assets and foreign issues. And he will say a few words as well about the importance of lasting powers of attorney. And then we're going to move on to Adam, and Adam's going to cover a fair bit of ground. He's going to cover the benefits of charitable giving, then move on to the use of deeds of variation in estate planning, talk about the importance of estate planning in advance of business sales in particular, and also how trusts are used quite commonly in estate planning, and some of the various tax rules associated with using trusts. And then finally, we're going to move on to Stephen, and Stephen's going to talk about the use of family investment companies in estate planning. He's going to explain some of the main lifetime gifting rules, and also cover off the benefits of pension death benefit planning, certainly getting pension death benefit planning right. The plan is to allow a little bit of time for questions at the end, and I hope you enjoy the session. Thanks, and over to you, Jacob.
Thank you very much, John. So I'm going to be introducing some of the main themes of our private client planning, including wills and LPAs. I'll start by going a little bit of ground of what sort of wills are usually used, and why we use those sorts of structures regularly. And then I'll talk specifically about a modification to that sort of will planning for business owners and other people who hold relievable assets. So to start with, if we're advising clients on wills, most often that will involve some form of will trust. So it's not a trust created during lifetime, but it's a trust that goes into the will and states that on death, assets will pass into that trust. And there are a few reasons why we strongly recommend the use of trusts in wills under English law. And that breaks down into three main categories. So the first key benefit of that kind of structure is the flexibility. It enables the family to adjust to changing circumstances both before and after death. The second is asset protection and control, in that it's possible to ensure that those assets are kept separate from the estates of the people inheriting those assets, kept under the control of trusted individuals, whether those are trusted family members or professionals, and just generally helps protect those assets from attack by outsiders. And the third reason is the tax advantages, and I'll be detailing some of those tax advantages in just a moment. I'm going to cover in the next, not the next slide, the slide after, a little bit on assets in foreign jurisdictions and how sometimes those need to be treated differently. That's a specialist subject of mine, and I'll be giving a full separate webinar on the subject, but I'll touch on it today. But the first thing that I wanted to talk about in terms of how this planning might work for clients with slightly more complex circumstances is clients with relievable assets. A lot of the time for us, that's people who own their own trading business. For others, it might be owners of agricultural land. And for even more people, it might be people who have invested in certain assets which qualify for relief, including shares on the alternative investment market. So moving on to the next slide, we can look at how we would advise one of these clients to structure their wills. So I'm going to start at the top and work my way down to explain how this process works. But the idea here is that a married couple who own an asset that qualifies for relief, and let's, for this purpose, say that it's shares in in the family business. If those shares can pass free of inheritance tax, provided they meet certain requirements. And if it's a trading business owned by the family, it's likely to meet those requirements if it's been held for at least 2 years. Assets passing to a spouse also pass tax-free. So the deceased could leave assets to the spouse, in which case there'd be relief. The deceased could also leave these trading business assets to the children, qualify for relief, or into a trust for the benefit of the children and the spouse, and that would also benefit from relief. However, there's actually a structure that can be used, a modification to our usual recommended trust, which enables additional planning so that we can use the relief again on the death of the surviving spouse. So across the death of both the husband and the wife, whichever of them dies first, we might be able to benefit from the relief twice, and therefore increase the relief for the family and the benefit for the children. So starting at the top, we have spouse one. It doesn't matter whether it's the husband or wife. I think for this purpose, let's assume it's the husband, who owns a relievable asset. And for this, we'll say it's shares in the family business. On his death, he needs to leave his assets into a trust, a particular trust that we call the Mills and Reeve two-fund trust. This is split into 2 sub-funds. On the left, we have a fully discretionary fund. That's for the benefit of the spouse and for the children, and under the discretion and control of the chosen trustees. Into that fund, the will pass the relievable assets. That will include the shares in the family business. It will include any tax-free allowance, the nil-rate band, and will pass free of tax by nature of the assets passing into it. The other sub-fund on the right-hand side of the screen is also flexible and available for use by the spouse and the children, but it's modified very slightly from the discretionary fund in that it gives the surviving spouse a life interest. That is, they have, at the initial creation of the trust, a right to the income that arises on that side of the trust and the use of the properties that are held in there. So that might include, for example, the family home would pass on that side. And the reason for that is that that qualifies for the spouse exemption because it's treated as passing to the surviving spouse, even though it's held in the trust. So we have all of the assets held in a single trust under the management of the chosen trustees. It's a very flexible setup. It benefits from all of the advantages I said before, including asset protection and control. And it also enables the following planning. So now that we have everything in a single trust and the estate administration is complete, it's possible to rearrange the assets within the trust. This is a standard tool that's existed for a long time to enable trustees to move assets within a trust so that they're best placed to meet the needs of the beneficiaries. So in this case, what we would do is we would identify the shares in the family business in the discretionary fund. We would match it with an equal value of assets in the life interest fund for the spouse, and we would exchange those assets. So the planning is limited by the greater of the two. If the shares in the family business are not worth as much as all of the other assets the family hold, it'll be limited only to the shares in the business. Or if the shares in the business are massively in excess, then it'll be limited by the value of the other half. But what you can do is you can switch those assets around, and the exchange itself is ignored for almost all tax purposes. It's not a sale, it's not a transfer, it's not a gift. Everything is staying within the trust, so there's no capital gains tax, there's no inheritance tax, and there are no transfer taxes like SDLT or stamp duty on a share transfer. The advantage now is that we have, on the left-hand side in the discretionary fund, we're now holding assets which are in and of themselves assets potentially subject to inheritance tax, but they're no longer owned by an individual or held in a trust that's treated in that way on death. So there is no inheritance tax on those assets when the spouse dies. On the other side, we now have relievable assets being held in the spouse fund. Now that fund will be subject to tax on the death of the surviving spouse, but provided that those shares in the family business have been held for at least 2 years, they will once again qualify for relief on death and thereby achieve the savings a second time around. And using this, it's potentially possible to have not only the 40% inheritance tax saving on those assets, but actually double that and achieve an 80% saving across those assets and other assets. There is potentially tax leakage on the half of the trust on the left, the discretionary fund, because there's a potential inheritance tax charge every 10 years of up to 6% on the value of the assets held there. But those 6% charges take a very long time to build up, even to 40% charge, let alone the second. So if we can move on to the next slide, please. The next point I wanted to cover briefly, and I do cover this in more detail in a future webinar, is foreign assets, because the structure I've just described works very well under English law for English assets, and is highly recommended for clients with those assets. And even for clients without those assets, often a discretionary trust is recommended, as I said at the start. That's not necessarily the best option where foreign assets are held. And for this, I'm thinking of holiday homes abroad, or typically shares in foreign companies, as long as their minor investments are fine, but any larger asset owning outside of the UK. For those assets, it's absolutely critical to take expert advice. That includes taking advice in the foreign jurisdiction, but also critically someone who can advise on how the two jurisdictions' laws interact. Because, for example, if there are assets in the UK and assets in France, it's possible to be advised very well in both jurisdictions, but if neither the lawyer in the UK nor the lawyer in France understands the cross-border implications, you can run into some really serious problems when the death happens and it's time to start moving assets around and deal with the administration. So most commonly, the right answer is to have a foreign will for those assets. It's not that an English will wouldn't be recognised, it's that it's much, much better to have a foreign will dealing with foreign assets. And there are three main issues to consider, and I go into these in much more detail in my separate webinar. They are foreign succession rules, because in lots of jurisdictions, including many of the EU countries, people do not have freedom to leave their assets to whoever they like, and indeed they're forced typically to leave a certain proportion split equally between the children. And it's important to make sure that either you're adhering to the local laws or that you're taking the necessary steps to apply English law in preference to those local laws. The second issue is foreign tax. Even if it's possible to do whatever one wants with that foreign asset, you might find that leaving it via the UK trust in the will leads to significant tax consequences in those jurisdictions. Again, in particular, I'm thinking of EU jurisdictions who really don't like trusts and tend to apply rather penal tax penalties to local assets which pass into them. So it's important to make sure that the structuring is appropriate for those assets, which often means keeping them out of a trust, even though in the UK we might quite like the use of those trusts. And the final point is practical issues, because although there might be a way to deal with the succession issues, and we might find a solution that minimises the foreign tax and the tax between the two jurisdictions together, but for practical operation of the administration, it often makes sense to have a separate local will in that jurisdiction for those assets. It speeds things up, it makes things clearer for everybody involved, and generally leads to lower costs than ignoring it and hoping it'll all work out under the English will. So having talked about wills, next please. I just want to say a few words about lasting powers of attorney. It's a good idea whenever considering will planning to spend a few moments thinking about lasting powers of attorney, also known as LPAs. They're often forgotten or not considered, or some people think that they're covered by the will in some way. The will covers assets that will pass on death and what happens to those assets on death. But if the same person doesn't die, but instead loses mental capacity to handle their affairs, their will doesn't kick in. They're still the owner of their assets, but they're no longer able to deal with them. So it's important to think about who would be put in control in the event that there was a loss of capacity. It's absolutely critical to choose the right people, trusted family members typically, to act as this attorney. And there are two separate forms, both of which should be considered. The first is property and financial affairs, dealing with the assets of the person who's lost capacity, deciding, paying their bills, and deciding how to invest. and what to spend money on. There's a separate LPA for health and welfare decision about where the individual will live, what kind of medical treatment they receive, and indeed in life and death situations, whether or not they receive life-sustaining treatment. It's important to put these in place in advance, not least because if these aren't considered and aren't put in place and aren't registered in advance of a loss of capacity, the process becomes much harder. It's still possible, of course it's still possible, to have someone appointed to manage these affairs, but it involves an application to the court for a deputyship order, which is more expensive, more time consuming, at a time when really the family could benefit from something much easier to deal with. Finally, I want to say a few words about living wills, because it's another thing I get asked about. Living wills is similar to a health and welfare LPA in that it covers the kind of care that one might receive when one's lost capacity. But instead of appointing somebody else to make those decisions, it tries to set out what kind of treatments would be acceptable in what kind of conditions. Now, there are some challenges to that because no one can predict every possible outcome, but they do have one advantage over LPAs, which is that they have a stronger legal binding on the medical professionals. In most cases, the vast majority of cases, an LPA for health and welfare will do what is needed for a doctor in almost every case. However, there could be some circumstances in which a doctor feels very strongly about a particular form of care and is able to override the opinions of the attorneys. However, under a living will, it's possible to exclude them from doing so, and they can be legally bound to follow it in a way that an LPA can't quite achieve. I think that's quite enough from me on LPAs, so I'm going to hand over to Adam to talk about charities.
Thanks, Jacob. So hello everyone, I'm going to start by talking about charitable giving. A good estate planning tip for professional advisors giving the advice is to begin the exercise by having a general conversation with a client to establish the why. Why are we having this meeting? Ultimately, what is the wealth for? What does the client want to do with it? What interests them? Having that discussion enables you to really get to know the client, and you may find you end up talking about charitable giving, perhaps because they already had it in mind, or perhaps because they really don't know what to do with their wealth, but you touch upon something during your conversation that triggers a particular interest or concern and opens the door for you to say, have you thought about this? If there is an interest in charitable giving, there are options as to how to go about it. Gifts can, of course, be made during lifetime. As a boring tax lawyer, the temptation is always to immediately pounce on the potential tax advantages of making lifetime gifts. I have to say, however, in most cases, it's not going to be tax driven. People that give during their lifetimes do so because they feel very strongly about something. They want to make a difference and they want to see that difference being made. Having said that, it would be remiss not to pay attention to the tax relief that can be obtained to do what you can to try and maximise the benefit from it. So the first thing to note on that front is from an inheritance tax perspective, a charitable gift will immediately reduce your estate for inheritance tax purposes. There's no need to survive that gift by the usual 7-year period. If you give assets standing to gain, such as property or shares, that gain is wiped clean, so no capital gains tax. And you can also get income tax relief, either on gifts of certain qualifying assets or on gifts of cash. For gifts of cash, a higher rate taxpayer can claim back the difference between basic and higher rate tax on the sum donated. The only caveat to that is you must have paid a total amount of income tax or capital gains tax in the tax year in question that is at least equivalent to the amount you are seeking to claim back. Quite obviously, you can't claim back tax you haven't paid. If therefore you wanted to make a significant charitable gift, but not paid enough tax in the financial year in question to claim back all of the tax that you potentially could on the sum being gifted, it may in those circumstances make sense to stagger the gift across different tax years to maximise the tax relief that you can benefit from. Gifts can also be made on death by will. Again, no inheritance tax to pay on the value of that gift. And as with lifetime gifts, no capital gains tax. Any gain is wiped clean. The added bonus here is if you give 10% or more of your net estate to charity, the rate of inheritance tax that applies to the rest of the estate going to chargeable beneficiaries is reduced from 40% to 36%. This is therefore a highly efficient way, a really effective way of giving to charity, and it can save significant amounts of inheritance tax. What if you don't want to wait to give on death? What if you want to start during your life? How do you go about it? What's the answer? Well, before answering that question, there's a more important question to consider, and that's the why. Why are you giving? What are you seeking to get out of it? And the answer to that question will help determine what the process is, how you should take things forward. So to give you a few examples, if a client said to me, I want to make a donation to charity, no wish for any ongoing involvement, they can do what they want with it, and I'm not planning on making any further gifts at this stage, the answer to that, the advice that you give is obviously very straightforward. It's an easy one. Make an outright gift. If, however, a client said, I want to put some money aside now to provide a fund from which I can support a number of different charities, and I want to do it in the easiest possible way without any hassle, I would say in those circumstances, it's worth considering a donor advised fund, which is essentially a charity account. The provider of the account does all of the hard work in terms of dealing with compliance, obligations, duties, ensuring you're on the right side of charity law. And all the donor has to do is simply confirm his or her wishes in terms of which charities should benefit. So you get all of the good stuff, but without the misery of the legal compliance that sometimes goes with it. Having said that, for some of our clients, particularly at Mills and Reeve, it isn't just about giving. They see it as a project to engage the family in matters of genuine personal interest, while at the same time encouraging the next generation to develop their own sense of social value, financial responsibility, to give them a taste of perhaps what they may come to experience with the family business later on. For those clients, setting up a family charity may be the right thing to do. It may be the answer. And if so, the next step would be to discuss what type of charity it should be, and crucially, what legal structure it should adopt. Charities can take the form of trusts, charitable incorporated organisations, or charitable companies. One size does not fit all, and the right structure, the right one to go to, will depend very much on the specific circumstances in terms of what assets will go into the charity, how it will operate, and what the client is seeking to do with it, what activities it will engage in. That is a talk in itself, and so I'm not going to go into any further detail on that for the purposes of this webinar. Instead, I'll move on to the next slide, please, Claire. Talk about my next estate planning tip. Deeds of variation. Nothing new here. Since I've been qualified, people have been saying deeds of variation, not sure they're going to be around for much longer. They may well be attacked in the next budget. So I didn't think we'd still be talking about them now. But they haven't gone. They are still around, and they are extremely useful if used in the right circumstances. So I expect many of you may know what a deed of variation is, but just by way of refresher, if you receive a gift from an individual on death, you effectively have 2 years to rewrite the will insofar as that specific gift to you is concerned. If there's no will and you're benefiting under the intestacy rules, a deed of variation can apply to that gift as well. Why is it so valuable? Well, it's because it enables you to redirect the gift. So effectively you make the gift, but without that gift being seen to come from you for inheritance tax and capital gains tax purposes. It's therefore perhaps the one occasion in which you can have your cake and eat it. You can redirect the gift into a trust, be a beneficiary of that trust, and although you coordinated the whole thing, as the gift technically came from the deceased, those gifted assets sit outside your estate for inheritance tax purposes. The only downside is you would be the settler of that trust for income tax purposes, and as such be liable for any income tax on any income generated by the trust So there's no rebate for income tax, it's only for inheritance tax and capital gains tax, which is a point to bear in mind, sometimes overlooked. When is a deed of variation worth considering? I can give you two examples when it's almost a crime not to do one. The first one, typical scenario, parent needs a gift outright to a son or daughter. Son or daughter is married with their own children. They have their own inheritance tax problem and are keen to minimise tax for the benefit of their children to ensure that the children get the maximum amount they can from the estate. Without question, in those circumstances, a deed of variation is the right thing to do. It provides an answer. Second example isn't as common. I've talked about this before in other talks, and I don't have time to go into great detail on it today, but briefly, I mentioned there is a reduction in the rate of inheritance tax if you give 10% or more of your net estate to charity. What I didn't say is there is a 4% tipping point. So a gift of 4% of the net estate should always be rounded up to 10%. The reason is if you give 10%, the other beneficiaries of the estate get exactly the same as they would have received if you'd gifted 4%. The difference comes out of the tax. So HMRC effectively pays for it. And if the gift was 7% of the net estate, the other beneficiaries would actually be worse off and get less than they would have received had you actually given 10%. So given that strange quirk in the law, if I was dealing with the administration of an estate and I spotted a charitable gift and I did the sums and I calculated that the overall value of that charitable gift sat somewhere between 4 and 10%, chances are I'll be recommending to the client that the appropriate thing to do and the right thing to do is to do a deed of variation to top it up to 10%. Next slide, please, Claire. Okay, next tip is one for business owners. If a sale of a business is on the horizon, start thinking about pre-sale planning early. That's the crucial point. Business asset disposal relief, the old entrepreneur's relief, can potentially save significant tax. It halves the rate of capital gains tax from 20% to 10%. To claim it, there are some conditions that need to be satisfied. The shares have to be in a trading company. As owner of the shares, you have to be an employee or director of the company. And it must be a personal company, which means you must have at least 5% of the ordinary share capital and voting rights and be entitled to at least 5% of the proceeds or assets on a sale or in the event of the company being wound up. Two other really important points to be aware of. First of all of those conditions that I just mentioned need to have been satisfied for a period of at least 2 years pre-sale. Second point, the relief is subject to £1 million lifetime limit on gains, which means the maximum amount an individual can save is £100,000. So what can we take from that? Well, two things. First of all, as I said, think about this planning early. Think about it at least 2 years in advance if possible. Assess whether this relief is likely to be available. Secondly, if you think it is going to be available, is there anything you can do to maximise the benefit that you can get from it? Having the shares in one person's name limits the potential saving to £100,000. Giving a proportion of the shares to a spouse at least 2 years in advance could double the saving. You could take it a step further and bring the children into the business to make use of their £1 million allowances. Each one you bring in potentially save another £100,000. Alternatively, you could consider using a trust for added protection. Provided the shares qualify for business property relief, there should be no, or business relief I should say now, there should be no inheritance tax charge on the transfer into trust. One slight caveat, one point to note, if you were to die within 7 years of making that transfer into trust, the relief could potentially be clawed back and a liability could arise. That would be something to monitor. You would need to ensure the trust has a qualifying beneficiary if you proceed to make that transfer. In terms of what I mean by that, you need to have somebody that satisfies the necessary conditions that I've talked about, to whom you could give an interest for a period of at least 2 years. So in summary, to take advantage of this relief, quite a bit of planning, quite a bit of thought is required. But if it works, if it's executed properly, the saving should more than justify it. So it's an important one to bear in mind. It's an important one to consider. Start thinking about early if you can. Next slide, please, Claire. Final tip from me, and again, nothing new, revolutionary here. Make use of trusts. A married couple could each transfer £325,000, so a total of £650,000 out of their estate and into trust without triggering an inheritance tax charge. If they survive that by 7 years, they can do it again. Cash or other assets can be gifted into trust. If you're putting property or shares into trust and those assets are standing at a gain, you can make use of holdover relief to avoid capital gains tax arising on the transfer. Typically, trusts are set up for children or grandchildren. That's what most clients are interested in. You may, for example, want to help one of your children get on the property ladder. But you know, if you give them the money outright and they go off and purchase a house in their own name, that comes with a risk. What if they go off the rails, get into financial difficulty? That could present a problem, could have a creditor seeking to get hold of the property. Or alternatively, there may be a boyfriend or girlfriend on the scene that you have concerns about. In those circumstances, the safer course of action would be to go through a trust. So you put funds into the trust then buys the property for the child to occupy, provided that child is given an interest in possession in the property, so a right to occupy and benefit from it, and that child owns no other property, there should be no stamp duty land tax surcharge on the purchase. As well as that, on a subsequent transfer, principal private residence relief should apply, avoiding capital gains tax arising if the property increases in value. More importantly than any of that, however, you provided financial support for your child as intended, but you've done so in a protected way. You've built in some protection. If somebody wanted to come along and get their hands on that property, it would be difficult for them because the capital would be ring-fenced within the trust structure. Another common use of trust to finish on is to help fund grandchildren's school fees. This is efficient from an inheritance tax perspective because provided the gift is survived by 7 years, it gets a lump sum out of the grandparents' estate, reduces the value of their estate subject to inheritance tax. It's also really useful for income tax purposes as the trust income can be taxed as though it's the grandchild's income, making use of each grandchild's own income tax allowance. Worth noting, this income tax benefit only applies to trusts funded by grandparents, not parents. If a parent tried to fund their own child's education through a trust, they would be taxed as though the trust income was theirs. It wouldn't quite offer the same advantage. And that's it for me. So over to you, Stephen, to finish up.
Thank you, Adam. So for those of you who don't know me, my name's Stephen Atkinson and I'm a Principal Associate in the Private Client team. I'm going to speak to you about the final 3 topics today, which are the use of a family investment company as part of your estate planning, some matters to consider when making lifetime gifts, and finally, your pension as part of your estate planning. So firstly, family investment companies. Adam's just explained how a trust can help clients to pass on assets whilst retaining control and protection. What if you wish to pass on assets far in excess of your nil-rate sums without an immediate charge to inheritance tax? This is where you should be considering a family investment company, or as we call them, a FIC, as part of your estate planning armoury. Like a trust, a FIC is a structure allowing you to pass on assets for inheritance tax purposes, while both protecting and retaining control and investment of those assets gifted. So what are the key features of a FIC? So it's just a company incorporated under the laws of England and Wales, but with bespoke articles of association and shareholders agreement, and therefore not subject to the regulations of the FCA. Control and ownership are split like a trust. Ownership is with the shareholders and control is with the founder directors. Shares are generally held by the client's children, their grandchildren, and family trusts. Minors are able to hold shares, but generally hold through their trusts. Alphabet ordinary shares will be used to provide flexibility over the payment of income. And dividend income received by a FIC is not subject to corporation tax, making the FIC a useful long-term tax-efficient vehicle. So now I'll cover some more points in greater detail. So the first bullet point is, what are the inheritance tax advantages? A FIC can help a family manage their exposure to inheritance tax in two main ways. So first, when the FIC is formed, shares can be given to family members without any immediate tax charges. And after 7 years, the full value will pass outside the founder's estate for inheritance tax purposes. Where the shareholders have a minority interest in a FIC, the value of their shareholding will be discounted on their death for inheritance tax purposes, taking into account the size of their shareholding and their inability to sell the share or to demand income. So the next bullet point is one of the key points that you need to understand is, how do the founders retain control of those assets gifted? Unlike a normal company, control of a FIC is with the founder directors and not the majority shareholders. A key point to understand here is we provide control to the founders in a way different to most other firms. Other firms generally provide control through the founders holding voting shares and the family members holding non-voting shares, but holding the wealth in the company. The problem with this is that even if the founder holds only £1 share out of 1 million shares in issue, that single voting share will be valued by HMRC at up to 25% of the total value of the company. This is because if you control the votes, you can rewrite the Articles of Association at any time so that your share has the right to income and/or capital. Not only does this hugely impact on the efficiency of the inheritance tax planning, as the founder retains up to 25% of the gifted value, but it also causes a major headache should the founders wish to add value to the FIC in the future. Calculating the value of voting shares and non-voting shares is highly technical. As we provide control to the directors through the interaction of bespoke Articles of Association and shareholders agreements, all our ordinary shares have equal rights to vote, to income and to capital, making matters much more straightforward on the death of a shareholder and when adding further funds. The next bullet point covers the protection provided by a family investment company, which is always one of the key focuses, protecting wealth for future generations. Our bespoke Articles of Association set out tailored procedure for share transfers. In general, all transfers require the approval of the founder directors, other than those transfers to their bloodline or appropriate and pre-approved family trusts. Obviously, a FIC can't prevent a divorce or bankruptcy of a shareholder, but it can mitigate that damage. In these circumstances, our articles provide for compulsory transfer of shares. On being made bankrupt, the articles provide for the shares to be bought back at open market value, retaining the shares in the family and keeping the FIC assets protected. And similar applies on divorce. The family court will see the FIC shares as a financial resource within the joint marital assets. But as a transfer of FIC shares out of the family needs board approval, the court cannot force a transfer. The court will look to the shareholder for equivalent value, but the value is very much up for negotiation, and there should be a significant discount on the value of any minority shareholding. That being said, the best protection is always a pre or post-nuptial agreement. The next step is considering the use of a family trust as part of the FIC structure. There are several benefits from using a trust to hold FIC shares. And so the trustees can be given the power to appoint the founder's choice of new directors in the event of a family accident wiping out the board, which ensures the founders continuing control, appointing who they wish. As an additional shareholder, the trustees will assist in reducing the overall percentage ownership of each shareholder and increase the likelihood of obtaining minority discount. The trust, generally being a discretionary trust, adds extra flexibility over payment of income. Shares can be transferred to new grandchildren from the trust without incurring a capital gains tax charge due to the availability of holdover relief. And finally, the trust adds an extra layer of protection over the value it holds from divorce and bankruptcy. So if we can move on to the next slide, please, Claire. The one before that, please. Thank you. So now I'm going to talk to you about lifetime gifting. As I'm sure you all know, the general rule is that when you give away an asset, this is considered a potentially exempt transfer or PET for inheritance tax purposes. This means the ownership of the asset is given away immediately, but you must survive 7 years from the date of the gift for its fallout of consideration on death. If you die within 7 years, the failed gift will first use up your available nil-rate sum, and the balance of the value will be charged to inheritance tax at 40%. Tax is generally payable by the recipient of the gift, and if your nil-rate sum has been exhausted, if you survive 3 or more years from the date of the gift, the tax payable on the gift tapers. One point to bear in mind is that tax is paid on the value of the date of the gift, not the date of death. So even if you die within 7 years of the date of the gift, you've got the growth on that gift outside of your estate. 3 other points for you to consider when considering making a gift are: what asset should you gift? Obviously, cash is straightforward with no CGT considerations. Other assets like investments or realty, you need to consider whether they've increased in value and whether there's any stamp duty or stamp duty land tax consequences. Even if CGT is payable, you should balance this against the potential larger inheritance tax saving. What's the likelihood of the donor surviving 7 years? Finally, are you happy to transfer the asset outright, or should you be considering using a trust or family investment company to allow you to retain control and investment of that asset gifted? One exemption to the PET rule is the normal expenditure out of income. Where conditions for the exemption are met, the gift is immediately exempt from inheritance tax, and there's no need to survive 7 years. There's no limit on the amount of this exemption that can be claimed. The first of the 3 conditions to satisfy is that the gift must be made as part of your normal expenditure. HMRC regards normal as typical or habitual. When considering the claim for exemption, HMRC will expect to see a settled pattern of gifts, ideally through the 7-year period before death. The exemption would be easier claimed if the gifts are of a similar amount or to a defined class of people. If you die too soon to show a settled pattern, HMRC will accept proof of a commitment regarding your future expenditure. Such a commitment could be, say, payments of premiums on a life policy for the benefit of another, or payments under a deed of covenant. The second condition that must be satisfied is that it must be made out of your income. There's no definition of income for this purpose, but HMRC's view is that this is your net income after payment of income tax and determined for each year in accordance with normal accounting principles. The key here is that you keep detailed records of both your surplus income and the gifts you make. The exemptions claimed by your executors on your death, so the information that you retain will be key to a successful claim. The third and final condition satisfied is that after allowing for all gifts forming part of your normal expenditure, you must be left with sufficient income to maintain your usual standard of living. And this is a subjective question for each person in each case. The key is to keep a close review of your income to ensure always that there is sufficient income surplus to cover the gifts that you make. Finally, for Mills and Reeve, a way that we can assist. If you lose capacity, your attorneys under your lasting power of attorney or your enduring power of attorney have limited scope to make tax planning gifts. What you can do is put into place a deed of covenant whereby you covenants give away all or a percentage of your surplus income on an annual basis. If this is in place when you lose capacity, your attorneys are able to continue to make the gifts. This will not prejudice your access to your income going forwards, as many people fear. If your income is exhausted by care fees, you have no surplus income to gift, so no gifts are made. So Claire, can we move on to the next slide for pensions? Thank you. So finally, let's consider planning using your pension and the pension death benefit. So some of the relevant considerations are pension funds can be a significant family asset, often amounting to several hundreds of thousands of pounds. Your pension death benefit is one of the few assets in most cases that are inherited free of inheritance tax. Most pension arrangements give the pension trustees a discretion to decide who inherits on death, and it's these arrangements that I'll focus on. The income tax treatment is dictated by the death of a member either before or after the age of 75. And finally, when considering planning, most clients will wish for the pension funds to be available to support their surviving spouse or civil partner. So the pension freedoms introduced in April 2015 meant that the person inheriting the death benefit generally has three options on how they take it. They can take a lump sum from the pension. They can use the pension death benefit to purchase an annuity, or they can commute the pension death benefit into a continuing pension and take flexible drawdowns. So what's the tax treatment since April 2015 changes? My summary is based on the assumption that the lifetime allowance has not been breached by the individual in question. For the death of a pension member under the age of 75, uncrystallised and crystallised funds are now treated in the same way. First, there's no charge to inheritance tax on the death of the member. And second, amazingly, there's no charge to income tax on withdrawals from the pension by the person inheriting, whether that be by lump sum or funds retained within the pension. For the death of a member over the age of 75, again, there's no charge to inheritance tax on death, but the individual inheriting is chargeable to income tax at their marginal rate or at 45% if a trust inherits, whether that be by lump sum or from funds retained within the pension. Next bullet point covers who can benefit from the death benefit. The pre-April 2015 rules only allowed dependents to inherit. That included spouses, children under the age of 23, and financial dependents. Great news is now anyone the member wishes to benefit from the pension can do so, as long as they've been nominated. Therefore, it's essential for clients to review their individual pension scheme rules and the letter of wishes that they have in place to ensure that all desired individuals are nominated. Next, on to the standard form pre-April 2015 planning. The default pre-April 2015 planning was for the death benefit to pass into a pilot discretionary trust, which allowed the surviving spouse to benefit from, but ensuring that the value of that death benefit was not chargeable to inheritance tax within the survivor's estate. Due to the April 2015 changes in tax treatments, this is no longer the default planning, but there is still a role for the use of pilot trusts, as they can provide an extra layer of protection on the death benefit where needed. Although it remains the case that the death benefit would suffer a 45% tax charge if paid into the trust on a death after the age of 75, is it not better to protect the remaining 55% than potentially lose 100% of the death benefit? On to the final point of bespoke nominations, the expression of wishes forms. Considering the complexity of who can inherit the death benefit, how they take their benefit, and how this is taxed, how a pension holder communicates his wishes to his pension trustees is of the utmost importance. 7 years on from the changes, many pension companies' standard form expression of wishes is still extremely basic, simply asking who should inherit and in what percentage. To ensure that the most appropriate outcomes are achieved, whether that's from a tax flexibility or asset protection viewpoint, we recommend that any expression of wishes needs to cover the multiple death scenarios, ensure the correct individuals are nominated, and to promote a full discussion with these nominees and their professional advisors following the death of the member. We at Mills & Reeve have prepared a bespoke nomination and expression of wishes form, which allows the pension member to communicate these exact wishes to the pension trustees to cover the more complex scenarios ensuring that the most appropriate outcome is achieved. We recommend, if you're going to consider any pension death benefit planning, that you at first come and have a chat with us about what we can offer. So that now concludes the substantive part of our webinar, and we'll move on to the questions section.
Thank you, Stephen, and thank you all. I do have 4 or 5 questions actually that have come in. Jacob, the first one relates to wills, and in particular the 2-fund trust structure that you were describing when you own assets that qualify for relief, and some assets that don't qualify for relief. Are there any circumstances where you wouldn't use that 2-fund structure that you described?
So the 2-fund structure is acceptable under all circumstances, because it's always going to be optional when the time comes. So even if circumstances change and it no longer provides any significant benefit, the decision at the time can be taken not to implement that planning. In theory, of course, it's possible that you could implement that planning and the surviving spouse could live for 80 years, but in most circumstances, that's just simply not going to be the case. So given the flexibility that the structure provides, it's an excellent structure, even if the tax saving is never used, and in the best scenario, doubles the tax saving on those relievable assets. So any client with relievable assets of that kind should certainly be thinking of having that structure to enable the planning in case it's relevant on death.
Thank you. Adam, I've got a couple of questions actually for you. The first one, I think you alluded to deeds of variation and slight question mark over are they here to stay. Do you think there is a chance that the government will shut them down in the near future?
Well, there's always that possibility. It's that I mentioned when I was going through the slides that it's the one chance you have to really have your cake and eat it, to effectively give something but continue to enjoy a tax advantage. So in that sense, there's always been that fear that it would be quite justifiable for the government to look at it and think, well, we're being perhaps overly generous on this one. Therefore, it might be something they choose to take away to maximise what they recover from inheritance tax. So it's possible, but as I say, we've been talking about that possibility for a number of years, for over 10 years, and it hasn't happened. And as far as I'm aware, there's no current discussions being held about that possibility. There's always a surprise. There's always a chance a surprise can crop up in a budget, but and that's always been the fear. But certainly no indication at the moment, as far as I'm aware. That
Well, so I suppose the top tip on that front is make sure you get your will structuring right in the first instance.
Absolutely, that's the key point. Rather than rely on it, it's nice that we've got it as a safety net at the moment, but the safety net may be taken away.
And the second question I've got for you, Adam, relates to charitable trusts and establishing charitable trusts, and that was, how much money would you really need to be putting into a charitable trust for it to be worth the costs and expenses of setting up and running?
This is a really common question, and the answer isn't quite as clear as you might think. So you may have heard people say, other advisors say, you really should be looking to put at least £200,000 in. Some people say £500,000. Some people may say £1 million. Otherwise, it's not justifiable. It's not worth the cost, the ongoing responsibility. I'd actually disagree with that. I don't think there is a financial limit, and I'll give you an example to explain why. I once set up a charitable trust for a family that wanted to support music students. They didn't want to give money to college, university. They wanted to pay it directly to individuals wanting to advance their education. They couldn't do that through a donor advised fund, because donor advised funds will only make payments in favour of other charitable organisations. They won't make payments in favour of individuals. So they didn't have that option. There wasn't a viable alternative. They didn't want to put much money in. I think it was about £100,000. So if you're assessing it purely on value, if you took a strict approach, you'd say, well, hang on, is it really worth setting up a charity for that amount, the cost of setting up the ongoing compliance? And the answer in that case was actually yes, it was worth it, because it did what the client wanted to do. It achieved what they were hoping to achieve, and there wasn't another option for me to point to say actually this might be more cost effective. So in answer to the question, I think it's less about value and more about what the charity is actually for, what you want to get out of it, and what the purpose of it is.
Thank you. Stephen, a similar question about at what level you would actually consider using a family investment company. You know, how much would you need again to make the sort of family investment company structure?
Okay. So when we as I said, when we're considering a FIC, the reason we're considering it is because we're looking to give away assets but retain control and investment of those assets. So if you're looking at a couple who've got their nil-rate bands available, looking to gift up to £650,000, a trust is still a valid structure, and maybe the default structure to be using there. If you're looking at over £650,000 or you haven't got your full nil-rate band available, FICs come into play. We generally recommend that a starting point for adding assets to a FIC would be £1 million. We have set them up for less when the aim of the clients have been to invest and grow significantly. We've set them up significantly more, but the vast majority of the FICs that we put into place, because of the costs of running the company and the setup costs, we generally recommend £1 million and upwards.
And can a family investment company invest in anything it chooses? And is there anything in particular that you wouldn't look to hold within a family investment company?
It has the full range of investments of a normal company, but you need to consider the tax consequences of investment in certain assets. Investment in certain forms of bond can bring about an annual charge, quite a punitive annual charge to tax it. But there's nothing special about a family investment company as opposed to a general England and Wales incorporated company.
And you wouldn't typically use it to hold properties lived in by members of the family?
No, there's the standard benefiting kind problems where you're having shareholders or directors occupying or using company property. So no, certainly not.
Thank you, everybody. I think that concludes the session. Thank you very much for listening. I do hope we've given you a tip or two to take away for your own personal circumstances. Please do get in touch if we can help in any way. Thank you.